And today for Money Chat, I thought I'd bring in a little bit about criminal histories for Seattle rental applicants not considered under the law, something that Seattle real estate investors should be aware of. The Seattle City Council passed an ordinance that almost completely prohibits landlords from screening prospective tenants based on their criminal histories. It's all about reducing the number of people living on the streets in Seattle. When taking applications, they won't be allowed to ask about criminal history. And in choosing tenants, they cannot reject them due to their criminal history. The only people who may be denied rental housing will be those that are sex offenders registered because of adult convictions, and landlords denying housing to such people will still need to demonstrate a really good reason, business reason for doing so. Now, the intent, according to the proponents for this, is to lower barriers to housing for people with criminal histories, who now often are rejected by landlords. Council members voted 6-0 in evidence of the ordinance for their civil right committee to the full council. Now, some landlords say being allowed to make decisions based on the criminal histories of prospective tenants helps them better safeguard their property and existing tenants. Landlord renting part of their own homes and sharing a kitchen or bathroom with the tenant will be exempt, as will primary leaseholders giving an authority by landlords to choose roommates. People renting mother-in-law apartments or backyard cottages on properties where they live also will be exempt, but microhousing units will be covered by the ordinance. Proponents of the ordinance say people who already have served their time shouldn't be penalized against by landlords. And they say people who have been arrested but not convicted also should be treated the same as everyone else. They also feel the criminal histories have enough punishment, from embarrassment to loss of job or losing the ability to travel internationally. Even simple misdemeanors can cause havoc years and years after the case is over. Punishing for housing and the ability to have a roof over their heads and to provide for their family is too much punishment, is the reason for the ordinance. Now, Seattle recognizes the issue and its intersection with the homeless crisis passed this new ordinance forbidding the use of criminal histories in rental applications. For Seattle residents, they're scared of living next to criminals. The city points out that there is no relationship between criminal history and tenant violation, and if some committed a serious violent felony, they are probably still in prison. Well, who knows about that? But landlords will have to do a deeper dive into the applicant's financial and other civil records. There's enough criteria outside of the criminal records that landlords can use to deny someone housing. Taking a look at previous evictions is an example that could provide evidence that the person applying is a financial risk, which would make it okay to decline them for that rental. Bottom line is landlords want to make sure that tenants are responsible, and this is still possible to deny if they are not. Now, there are approximately 11,600 homeless in King County. A count by All Home found 5,485 were unsheltered in January. That includes people living on the street, in abandoned buildings, as well as vehicles and tenants. More than 7,000 of those are considered homeless just in the Seattle area. The Seattle office of Civil Rights is empowered to investigate any claims of adverse action by landlords, which includes not just denying tenancy or charging higher security deposits, but also more minor offenses like refusing to add a current occupant to a lease. A landlord could then be required to pay damages, provide rent credits, or mitigation their actions through targeted advertising to affected communities. Now, these offenders will also have to participate in anti-bias training courses. Should a landlord not go through this education, they can be fined $11,000 for first offense, $27,500 for two within a 5-year period, and $55,000 for more than 2 violations within 7 years. Now, Seattle's already hit landlords with a raft of regulations on how they can use their property, including caps on move-in fees, strict limits on no-clause evictions for month-to-month leases, and requires to accept tenants on a first-come, first-serve basis. That gets really confusing as well, but that's a whole nother mini chat. Despite all of this, the Seattle City has one of the priciest rental markets in the country and worsens homeless's problems. So what do you think? Good intentions or bad policy? I don't know. I have mixed emotions about this law, but most likely it will follow in the other cities because that's typically what happens. So it's just the start for Seattle. And I just wanted to make sure if you're looking at investment properties, you know about these new laws because they will affect you. And that's Money Chat. Coming up next in the Money Hour, dangers of waiving your home inspection. Keith Medley and Brian Walker. Brian, I'm not going to forget you, from Final Phase Inspections right here at 1150 AM KKNW after this short break.